Hey everybody, this is Mr. Moppin coming at you with another APGov video. This is focusing rather on topic 3.6, taking a look at balancing, as you can see up here, balancing individual freedom with public safety and order. In this video, we're going to be taking a look at how this applies to the Fourth Amendment. When we do talk about the Fourth Amendment, it stipulates that we are protected from what we see in the Fourth Amendment as unreasonable searches and seizures. Now, of course, that's a very important and interesting phrase. The idea being is that we are clearly concerned as a nation, the Founding Fathers, about matters relating to privacy. Because the Fourth Amendment talks about ourselves, protection of ourselves, our papers, our effects, our possessions, if you will, from unreasonable searches and seizures by the government. Now, you might be thinking, why is the United States, so sensitive to this? Why were the founders so sensitive to this? Well, part of that sensitivity goes back to the merry old days of England when we were British colonists. And back in those days, the British government used to be able to issue what were known as writs of assistance. Writs of assistance were basically these generalized warrants that would be applied not to a person's specific possession, like a trunk or something, or somebody's possession like their boat, but rather themselves as a person. So in other words, you could, with a writ of assistance, search anything and everything associated with that person. It could be their home, it could be their papers, it could be their boat, it could be their carriage, it could be, anything associated with them. And as you can imagine, that would be a very invasive type of search to be able to do. Now, with our Fourth Amendment, we put limits on how far the government can search. And note, the language that the Fourth Amendment uses is that only upon probable cause and with the issue of a warrant can you engage in these types of searches. And note, even when a warrant is issued, it is to be specific to what is to be searched. So what the Fourth Amendment tells us is that first off, the government can do searches. It doesn't abolish that, but it does certainly put clear limits on what kind of searches can be done and the grounds for those searches. Bottom line, the Fourth Amendment is stipulating that if the government's going to be searching you or your possessions, they better have a darn good reason, and that search better be pretty darn limited as much as possible. So, with that being said, we have to talk about, some of these key concepts associated with the Fourth Amendment, one of those being probable cause. Now, probable cause is the assumption that the government can use based on evidence to assume that some illegal activity is either likely or has likely occurred. It's not a guarantee of criminal activity. That's determined through the process of a court, through a trial process. But it is, for the police, for the government, it's where they assume that something criminal has likely occurred, which would then lead to possibly an arrest or into what would become justification for a legal warrant. But the question that you kind of have to ask is, how do you then decide if something has achieved the status of probable cause? In other words, likelihood of criminal activity. Well, for the authorities, one of those ways is through the basis of what we call reasonable suspicion. Reasonable suspicion is, for lack of a better explanation, the idea being is that the police, the authorities, have a sense based on what they see and what they hear of something that is not right. Something's off. Something's not the way it's supposed to be. Now, note, this is based on what is being seen or heard. It's not based on a gut reaction. It's not based on pre-existing, biases or anything along those lines. So imagine, for example, a car is traveling down the highway and the police see that the car is swerving a little bit over the double yellow, a little bit over the right. That's clearly a sign that something's not right. Something's not happening properly. Now, does that mean that it's likely criminal? No, not based on the evidence. That swerving could be the result, for example, of somebody having a heart attack. But it does provide reasonable suspicion to allow the police to be able to stop and pull you over. Note, the government cannot just pull you over arbitrarily. There's got to be some legitimate reason for it, some degree of reasonable suspicion, etc. Now, if the police pull over somebody driving a car, they then have the ability to ask questions such as, what is your name? Please show me your license, proof of registration, proof of insurance, ownership, etc., etc. And if the police officer sees that the driver, for example, has bloodshot eyes, is slurring their speech, and then let's say they use that as the basis to do a field sobriety test, and that driver fails the field sobriety test, that then could be grounds for probable cause. The assumption is based on the fact that this person has bloodshot eyes, slurring their speech, can't stand up straight, that it's likely that they've committed the crime of driving while intoxicated. That is cause for arrest in that type of a situation. Now, if you are talking about a situation where probable cause would lead to a warrant, you would have to be able to show that there's some, once again, likelihood of criminal activity. You would have to, for example, let's say that there is a rash of drug overdoses in the community, and the folks that have overdosed on those drugs have said that a certain individual has sold them their drugs. And let's say that person's a student in a local high school. The person that's been named for selling drugs by some, folks that have overdosed, the school does a search of the locker. Now, note, the school's protected to be able to search that locker because that's not the student's property. That's the school's property. And let's say inside that school locker, they see things such as a scale, some small plastic baggies, things that could be construed to possibly be associated with, drug dealing. They use that information as well with some, other information that they've been using, for example, as we've been talking about. That could be enough, theoretically, to then go for probable cause, perhaps, and then go to a judge, and assuming that there's enough probable cause, in other words, enough evidence to show that there's a likelihood, a preponderance of criminal activity, then that judge would then be able to sign off on a warrant. Now, that legal warrant then gives the authorities the right to do a specific search. So it might be from the judge a specific search to search that individual's home, for example. And so what then happens is that with that legal warrant, the authorities have the right to then search, have the right to search that home. Now note, if the police go into that home with no probable cause and no warrant, just a gut instinct assumption that somebody is drug dealing, and they go into that house, then that's violating the rights of that homeowner or that resident of that home. And note, even if they were to find, for example, drugs in that home, if the search of that home was in violation of that resident's rights under the Fourth Amendment, that evidence would not be admissible under court. Any evidence that's found illegally or violating the rights of somebody else is inadmissible in court. Now, note, there are some things that we do have to be aware of with regard to some other aspects of dealing with issues of probable cause, reasonable suspicion, getting a warrant, etc. First off, there's always what's known as the plain view exception. Anything that's in plain view of the government, of the authorities, is basis for determining probable cause, to make an arrest, to get a warrant, etc. That also involves inviting authorities into your home. If you invite the police into your home and there is, drugs in your home, that's in plain view. You invite the police in, they've seen it in plain view, they don't need a warrant, they see the drugs, and that can be the basis for an arrest. Also, we've seen in recent years legislation that has allowed for much broader search capabilities at places like airports and the border. The basis behind this is to protect national security, protect public safety. And that then does raise some very interesting questions about how do you balance protections from invasive searches under the Fourth Amendment from balancing the need for national security and public safety. One of the great examples of this in the last 20 years or so has been the passage of the Patriot Act. The Patriot Act in 2002 is going to be in response to the 9/11 attacks. And this is going to give the government broader authority to be able to monitor communications by those that would be deemed as potentially involved in criminal activity, those that might be attempting to organize terrorist acts, criminal acts, things like that. Now, the Patriot Act, when it's enforced, when it's going to be implemented, is going to be done by the Bush administration, George W. Bush administration, and you're going to see executive orders be created and bureaucratic decisions be made that are really going to broaden this kind of government authority to be able to gain access to information and monitor communications of those that are not just non-citizens and not just those that potentially may have criminal activity, but really all Americans. One example would be the issuance of an executive order by President Bush that would allow the federal government, the bureaucracy, the Department of Justice, and Homeland Security to be able to contract with third-party communications vendors to be able to collect data from their customers. So in other words, the federal government was now able, via the Patriot Act, to reach out to, be it Verizon or AT&T or whomever, and basically say, hey, we want to know who this customer of yours is communicating with. We want to know who they're communicating with, on what days, how long the communications are lasting, etc., etc. And note, that's being done without a search warrant. That's being done without necessarily the permission or even awareness of the person in question. We also saw a couple of years later, as a result of the passage of the Patriot Act, we saw the creation through Homeland Security of what's known as the PRISM program. Once again, this is done bureaucratically. This isn't passed by Congress or anything like that. But the PRISM program is going to be started as a way to, basically force these internet service providers to provide on the internet search data information. So in other words, we kind of go from, as I mentioned before, the ability to contact, telephone companies to be able to see who people are calling and talking to, now being able to say, hey, we want to go to, some internet service provider like Spectrum, if you will, and say, hey, we want to know what sites so-and-so customer is visiting, and we want to know how long they're going there, et cetera, et cetera. And so what you're starting to see happening is, under the guise of national security, much broader ability for the federal government to have a sense of who you're talking to, when you're talking to them, what you're searching on the internet, what information you're getting access to, and things like that. And because of this broad ability for the federal government to collect this information, a lot of what's known as metadata, that's going to lead to some controversy, particularly following the leaking of information that's collected from these programs by this gentleman here, Edward Snowden. Snowden is going to be a former contractor that's going to be working on these programs, and he is going to become disillusioned, disenchanted, and will begin to leak information of how the U.S. government was using these programs secretly, without a warrant, to get access to communications, particularly with foreign countries and foreign leaders and non-citizens. The idea being is that his argument is that the federal government was violating its own values, violating the Constitution, in the name of trying to acquire more and more information about people. Snowden's claim is basically that the breadth of the implementation authority of the bureaucracy has basically allowed, as far as he's concerned, the ability of the federal government to pretty much get any kind of information that they want about anybody using any kind of, phone records, internet search data, whatever, about anybody at any time. And once again, without a warrant, without probable cause necessarily, and things like that. Now, note, he will be charged with violating the Espionage Act because, once again, this is top secret classified information that he leaked, and has certainly, had a negative impact on the ability of the federal government to engage in, intelligence gathering in those ways. So he has since left the United States. He's now been basically shielded by the Russian government. He's a resident there. But when we look at examples of the Snowden situation and things with the Patriot Act, it does raise one of these big, philosophical dilemmas. To what degree do we balance individual liberty and protections from the government versus the needs for security and protecting national public safety? Okay? All right, so we'll go ahead and leave it there for today. We'll see you there next time. Bye.